So today's presentation is on fraud. So fun with fraud, the practical use of fraud in Louisiana workers' compensation. Patrick and I recently gave this same presentation at the Louisiana Claims Association conference in Baton Rouge, and we get a lots of comments about fraud. We get lots of questions about fraud from our from adjusters and new adjusters and employers, and we deal with it a lot. And so really the purpose of today's presentation is to not only explain to you what fraud is, what constitutes fraud under the Louisiana Workers Compensation Act, but also how to use it strategically, even if you perhaps don't have the best case of fraud, how it can be helpful in alleging fraud in the course of litigation and even in claims that are non-litigated. So before we really get into it, so we are with Parker and Landry, as you know. Parker and Landry is a firm that's based out of Lafayette, Louisiana, but we have two offices, one here and also a satellite office in Alexandria, Louisiana. We have 7 attorneys. Our managing partner is Mike Parker. Our other named partner is Keith Landry. And then we have 5 other attorneys, that being myself, Megan Trahan, and also Andres Gomez, Corey Moe, Patrick Johnson, and Taylor Domingue. Combined, we have nearly 100 years of experience in defense experience. We focus primarily on Louisiana workers' compensation, but we like to think of ourselves as really a one-stop shop for employers. We have attorneys who do employment law, who do corporate litigation. We do general liability as well as workers' compensation defense. We also do immigration and collections for businesses. So if we can assist you in any of those realms or any of your insureds in any of those realms, be sure to let us know. We actually have an employers conference that's coming up sometime in September, that'll focus more on educating employers and things in that regard. But for today, we're going to focus on workers' compensation and specifically fraud. It's also helpful to know that we do represent many of the largest employers in the U.S. and Louisiana, but really that should say the world, because we represent the #1 largest employer in the world. So again, 2 offices, main offices in Lafayette and also Alexandria, but we do handle things all across the state. Yesterday, I was in Monroe for a deposition. I'll be in Metairie for another deposition tomorrow. We handle cases in all of the 9 workers' compensation districts in the state. So we do a lot all over. You want to introduce yourself?
Yeah, so as Megan said, I'm Andres Gomez. That's just a little bit about who we are as a firm and everything like that. And we're going to be putting on the presentation today. So if you have any questions or anything like that, feel free to reach out. All of our information is on the website, both Megan's and myself, as well as all of the other attorneys here. So if you have any questions or anything like that, feel free to reach out.
Okay, so without further ado, what is fraud? So I asked this at Louisiana Claims Association at the conference recently, and the overwhelming amount of participants said it's a lie. And like I told them then, I'll tell you now, it's so much more than that. The lie is what really opens the door to workers' compensation fraud. And while it's frustrating when a claimant or an employer or anyone does lie in the context of workers' compensation, that's only the beginning. Right? That should be the red flag. That should be the signal to tell you we need to investigate this for fraud. But that alone in and of itself is not sufficient to constitute fraud. I can't tell you how many times we get calls from newer adjusters or employers that they're frustrated, and rightfully so, saying the claimant lied, cut them off, this is done, we don't want to pay them anything else. Again, while that's good, not fraud in and of itself. So what does constitute fraud? We know it's not a lie. We just covered that. There are 2 types of fraud in Louisiana workers' compensation as defined by the Workers' Compensation Act. So you have 1208 fraud and you have 1208.1 fraud. I'm not going to go through and read the statutes to you, but know that 1208 fraud deals with an intentional misrepresentation made by any party for the purposes of either obtaining or defeating workers' compensation benefits. Then you have 1201 fraud, which involves a misrepresentation made by a claimant prior to the onset of a workers' compensation claim on the post-hire medical questionnaire. And so we'll kind of go through a little more in depth in the coming hour about what really constitutes fraud under those two statutes. But this is the only types of fraud that you can have here.
All right, so 1208 point fraud, as Megan mentioned earlier, it deals with a misrepresentation by any party for the purposes of obtaining or defeating benefits. And so it's important to understand that even though the exact verbiage of the statute is any person, really the intent is any party. Just like the claimant can be found to have been fraudulent in their misrepresentation, so can the employer, so can a physician, nurse case manager, claims handler, really anybody, as long as that misrepresentation is intentional and made for the purposes of obtaining or defeating benefits, then that can be pursued against any individual throughout the duration of the workers' compensation claim. The most common one, of course, that we think of is the claimant, right? They did something, said something, or failed to do something, failed to say something. And that kind of gives rise to the building of the foundation on a fraud claim. But just like that can happen with the with the claimant, like I said, it can also happen with the employer. There's several times where, opposing counsel will say, well, the employer or the TPA or the adjuster or the insurance company was fraudulent in that they said or did this or that. While that's not typically pursued, that is a claim that's available to them. No different than, for example, a physician or a nurse case manager that can make a claim for that.
So just to sort of give you a few examples of what could constitute fraud on behalf of a different party, right? So you have a claim handler, for instance, an adjuster who maybe they say that they didn't have an SMO when they do in fact have an SMO, right? We're only entitled to one physician in any field or specialty, right? So we can't go and have two different orthos. If they say they haven't had one when in fact they have, that could be fraud. What about a nurse case manager who goes and fills out the report to the status report after a nurse case management conference with a physician and intentionally misrepresents what that physician said? Or a physician, this is something that we've seen a lot recently. There is a particular provider in I would say the New Orleans-ish area that handles a lot of claims, is known as a treating physician. There's a network of physicians there. Body parts, or specifically traumatic brain injuries, seem to appear for every claimant that they see, right? So defense counsels, not just our firm, but other firms too, are working to sort of build a fraud claim against this particular provider. So that's definitely something that you should look out for. Also, employers. I had a case recently where an employer completely denied that an accident happened, or totally said that they never came to report a workers' compensation accident when the claimant did. And so the claimant ended up filing 1208 fraud against that employer. And so these are all sort of instances where any person or any entity, whether they are a party to the suit or not, could potentially have a 1208 claim lodged against them.
Okay, the important thing to consider is that it has to be willfully made. And so Megan provided you with some examples, so let me just piggyback off of that. Because a lot of times, not just the employers and adjusters, defense attorneys, plaintiff's attorneys, they'll all look at a lie and say, oh, look, we got fraud, when that may not necessarily be the case, simply because a statement is made that might not be accurate, or might be just flat out wrong, or it might be a lie. What the intent behind the statement, it will play a significant role. So Megan mentioned, with the providers, there are certain providers that will see a claimant initially and for a particular body part, for argument's sake, let's just say the back. The claimant will go in, will try to get treatment for the back, and then the adjuster will get a 1010 requesting an MRI for, the knee or the ankle or the shoulder, or just additional body parts, right? That should automatically throw up a red flag, because if those body parts weren't complained of initially, why are they complaining of this now? And there's been several instances where the claimant will say, well, no, I never complained about this. This is just being added. So the question then becomes is the provider being willful and intentional with the adding of the body parts, and what is the reason behind it, right? I'm sure there are several providers that just see it as an opportunity to make money. There's arguably even more providers that see it as, well, we get our business from the plaintiff's attorney. So if we can boost up the value of their case and the value of the claimant's case, we're going to get more business. And so the reason for the misrepresentation matters. It's not simply a lie. Oftentimes we'll have somebody that gets injured and says, I've never had any issues to this particular body part. And then once we start doing some digging, we get into litigation, we start conducting discovery, we realize, oh, wait, this person had, was involved in a car accident and got some treatment to that particular body part 15 years ago, right? Then the question becomes, okay, were you intentionally withholding that information, or did you just forget, right? If it was a relatively minor car accident, they went to a month's worth of physical therapy, and then that was it. Well, if that was 15 years ago, the fraud argument is far less effective than if they were treating up until the day of the accident and then deny it. And so anytime we're looking at a potential fraud defense, we have to be looking at what the information and what the evidence gives us in terms of what the potential intention could be.
So just some, like the slide says, there are other factors to consider. When you're considering a claimant who you're accusing of making a false statement or misrepresentation, you want to look at things like their level of education, right? If they have a 10th grade education, never finished high school, maybe they would have there'd be some argument there that they didn't understand the questions that were presented. So maybe they weren't intending to misrepresent that. You want to look at things like language barrier, right? Do they speak English? I know Andres is working on translating some forms. So like the 1205, the 1025 EE, and the 1020s, so that when you present them with the warning of 1208 fraud on them, that there's no way that they could misunderstand that, because it's also written in their native language. Also, another factor to consider is their mental capacity at the time. If they go to the initial medical treatment at the emergency room and they're on pain medications or hopped up on something else, that diminished capacity is going to weaken our intent argument. So you want to look at the state of mind at the time, their mental capabilities, all of these things are things that you would want to consider in kind of evaluating the viability of your fraud defense. Also, with regard to the actual statement itself, you want it to be objectively false, right? So you have evidence of X. You have evidence that they have said either to an SMO physician, to their physician, in deposition testimony, or somewhere they have made a statement that says that they are, for instance, incapable of doing anything other than laying around in bed. They can't take out the trash, they can't do dishes, they can't do work, or they haven't earned any income. And then you want your evidence that they are lying, for lack of a better word at this point, to be objectively false. they have X, you show Y. They have A, you show B. You want that to be verifiable. And that helps the argument that it was not erroneous or inadvertent.
Okay. The second portion of it is, again, the statement is made. The second is for the purposes of obtaining or defeating benefits. And so, as I mentioned earlier, the simple statement in and of itself isn't sufficient to automatically say fraud, right? We have to look at the intent behind it. And is it for the purposes of obtaining or defeating benefits, right? The reason that's for obtaining or defeating benefits is because, again, it's more than the employer and the claimant that can be tasked with fraud if the statement is being made. It's no different. The rule's the same for an SMO physician as a treating physician, nurse case manager, et cetera, like we mentioned earlier. And so when we're looking at this, we consider the relationship between the statement and the underlying claim. Again, if it's a situation where somebody has injured their low back, they go and they get treatment. Have you ever gotten, medical treatment for, the low back in your life? They say no, and 15 years ago they were. Well, were they intentionally withholding that information so that they would get a more favorable claim or value, or did they simply not remember? Were they treating up until the date of the accident, right? Did they have an attorney at the time? Because realistically, whenever a claimant goes and meets with an attorney initially, we kind of assume that the attorney is going to go over certain things with them and make them aware of certain things. Like, for example, if you do have any prior issues, then you need to make sure that you disclose those. If you have any sort of, other difficulties perhaps that you have not disclosed, then you need to make sure that those are disclosed. Easy example that I can think of right now is I had a case where the claimant, suffered a work-related injury. It was accepted as compensable. We had her go to the SMO, but during that time, probably about 5 months after the accident, she was involved in a car accident. We know from other records, not the records that we were receiving from the treating physician, but it started with a copy of an MRI that we got, an MRI report, which mentioned, oh, she had a car accident, and that led us to obtaining other medical records. Then when the claimant went to get the SMO, we asked the SMO specifically, please ask whether or not she's been involved in any accidents in any way, including but not limited to other accidents at work, car accidents, XYZ. And if so, did any of those accidents result in any complaints to any of her body parts? She denied that that particular car accident happened. Okay, so now we start looking at it again a lot more closely and start building on that fraud foundation, saying, okay, we know that you've been, that you had a work accident. We know that you've been treating for that work accident. We know that you had a car accident. And we know from the medical records that the complaints were to the same body part that were related to that she was complaining about for the workers' comp case. We know that she went see a different doctor, not her treating physician, but a different doctor altogether for those complaints. We know that she lied to the SMO. And we started kind of building on that, one on top of the other, to show that the simple fact that there was such a stark bifurcation of the two claims in and of itself speaks to that sort of intent. Now, is that solely sufficient to go in and say, well, clearly the intent was to obtain benefits? Well, no, you want more on top of that. You build on the foundation, getting as much evidence as you can. But the simple fact that she was already treating for somebody for that particular body part. She already had her physician and decided to go to a different physician altogether for the same body part after her car accident, which she never disclosed to anybody, like I said. It, again, builds on that. So you start stacking the tiles to be able to build the fraud and be able to extrapolate at least an educated guess as to what the intent was behind it.
So,
You go.
Okay, so I really want to hone in on the definition of benefits. So benefits in this context are specific to benefits that could be claimed under the Louisiana Workers Compensation Act. So that includes your indemnity benefits and your medical expenses, but also your mileage. So when they submit your mileage request, make sure saying that they went to the SMO physician or to their doctor, they need to be reimbursed for the mileage, which I believe the rate is just about to increase
On July 1st.
on July 1st. So that's something that we need to be mindful of. You're going to owe more. And so if they file a 1008 or something, like they could be entitled to a penalty for the improper payment of mileage. But with regard to fraud, when the mileage comes in, you want to verify those miles, right? And so because you're going to be paying in accordance with the amount of miles that are being alleged. If they are not really traveling to that doctor on that date, that's something that you want to be aware of because that could potentially be fraud. You want to know, are they really leaving from the place that they're leaving and going to the place that they are going? Again, that could potentially be fraud. But the degree to which it affects the claim is going to really be the determining factor there. Other benefits that it does not include or employment, right? So a lot of times we'll say, well, they lied on the post-hire medical questionnaire in order to obtain employment. Okay, that's 1208.1 fraud. That's why that does not fall under 1208 fraud.
And just again, the mileage is a very good point to make because a lot of times, less so now, but during COVID was especially prevalent in claims that the mileage is submitted well after. Because that's another thing to consider, that oftentimes we'll have a claim and they'll submit a mileage request a year after, right? They'll submit it once a year. So you got all these different visits. And so cross-referencing them, not only, like Megan said, the distance and everything like that, but again, like she said, whether or not they actually went, was it a telemedicine visit, things like that. Because that, again, it's any benefit. And also important with this is to understand that prejudice is not required, right? You don't have to have prejudice to the employer for fraud to apply.
Like they didn't have to have paid the mileage. They didn't have to actually have paid the indemnity benefits in order for there to be a viable claim for 1208 fraud.
Correct. The fraud contemplates the intention from the perpetrating party, not prejudice to the other party. So even if the employer did not pay anything that would support the fraud claim, or what let's, in this case, let's just use the example. If the claimant makes an intentional misrepresentation in order to get benefits, right? Let's say they're getting money from working, cash construction, and they're saying, well, I can't work. It's assumed that they're making that misrepresentation in order to obtain benefits. If the employer doesn't pay those benefits because they say, you know what, we know from surveillance that you're working construction, so we're not going to pay this. You don't have to pay it in order to get the fraud because, again, prejudice is not required. So that's an important thing to consider. Now, understanding the interplay between the intent, the statement, and what all that means and how it goes together, we now look to see, okay, how do we establish 1208 fraud? I've mentioned it a couple of times, but I like to think of it like building a house. You start with a foundation and then you stack things on there. In all cases of fraud, it starts with being able to identify the red flags. And while sometimes the red flags just sort of appear and are glaring, a lot of times the red flags need to be actually identified and found in the vast majority of cases. And so you want to kind of think of it as, with respect to fraud, and really with all claims, you want to think of fraud as something that's ever evolving and something that you're continuously kind of following back on. But it starts ultimately with the initial investigations, right? ISO report, recorded interviews, surveillance, social media. Those are the things that, at least a few of those, happen initially, right? With the reported interviews, a lot of companies have a specific checklist or a series of questions that need to be asked. But it's important to consider that if your company allows, to let the conversation lead you. Don't get so bogged down in the checklist that you miss potential follow-up questions that might reveal some additional information, right? Of course, you want to make sure that you're covering all the different things that you need to cover in your checklist. And that's good to go back at the end of the interview and make sure that you covered all those things. But let the conversation lead you to your follow-up questions. And not only will it be more conversational, it'll make the claimant feel a little bit more at ease, and that might prompt them to be more forthcoming with certain things.
I just want to throw in a shameless plug for one of these roundtables that we did a few weeks ago on recorded interviews and how to fine tune your recorded interview skills. Corey Moe and Patrick Johnson did that presentation, and it is posted on our YouTube channel, and it should be up on our website at this point. So definitely check that out. It can definitely be of assistance. We got a lot of great feedback on that presentation, and we hope that it's helpful for you.
Yes. And so with recorded interviews, it's important to remember, not just with recorded interviews, but everything, is that when we're establishing a fraud claim, everything interplays with one another. You're sort of weaving this web to connect the dots and be able to show the court that yes, this person did in fact commit fraud, because no claimant is going to show up in court and say, oh yeah, I lied on purpose so that I could get these benefits, right? It's up to us to be able to weave the web in such a way that's understandable to the court and shows what we needed to show. And so as you're going through the steps, not just the initial investigations, but later on as well, it's important to remember the interplay and how those things connect, because it might help you down the road. So oftentimes with recorded interviews, I'm a big proponent for asking certain questions that more often than not are not asked. And that is, do you have an emergency contact? And if so, what's their name? Do they drive a vehicle? And if so, what kind of vehicle is it? And do they live by themselves, or do they have any other person that lives in that house? And here's why those three questions are important. A lot of times, surveillance companies will do a people search of sorts that will give them a list of vehicles that either are registered or have been registered in that individual's name. But a lot of times, the claimant either doesn't drive a vehicle registered to their name or has multiple vehicles registered to their name. So when the surveillance crew goes out there and starts looking, you might have one of three vehicles registered to that person's name parked in front of the address, but there's no way to know whether or not the claimant is in there or out using the other two vehicles, right? And so at least having in the recorded interview, asking the question, what kind of vehicle do you drive? They'll tell you, oh, whatever, 2015 SUV, Ford Escape, blue, right? Well, we know, okay, that's more likely than not the vehicle that they're going to be driving. So that's information that we can give to the surveillance people. Their emergency contact or who lives with them, their roommates. Oftentimes, and it's becoming more and more common, when the claimant initially meets with their attorney is going to tell them, shut off your social media, deactivate any accounts that you have, or make them private to where you can't see anything and to where nobody can see anything that's not friends with you. Okay. Well, a lot of times, at the end of the day, social media can be very addicting. And a lot of times claimants don't want to make their profiles private, and they don't want to kind of withdraw themselves from that arena. And so what they do is they'll change their names. They'll change the names that they use. I've seen it a lot of times happen where, females will use their middle name and their maiden name, for example, or they'll go by a nickname on social media. And all they have to do really is change their names, and it becomes exponentially harder to find them. And where I've had a lot of success finding people on social media that I can't find just using their name is searching for, when I'm looking at the medical records, I'll look, okay, who's this person's emergency contact? Let me find that person on social media. And if they are close enough to be an emergency contact, realistically, they're going to be close enough to where there's likely posts with that person, right? Similarly, who lives in the home with them? A lot of times, that's a question that I'll ask in a deposition, because they'll have either, children that are teenagers or early 20s that might live with them, or a significant other, whether that be a fiance, boyfriend, girlfriend, what have you. So the emergency contact might be a parent, but the significant other might live with the person. And it's through the significant other that we've been able to find claimants as well. And so when you're doing these things, you want to make sure that you're aware of how these things connect and how you can use information obtained in one avenue for a more effective investigation in another avenue. Again, same thing, obtaining information with the recorded interviews, addresses, things like that, that might be identified in an ISO report that can show up and give us information about prior claims. And so in your initial investigations, the foundation, as I like to call it, that's going to be based upon what you are able to uncover initially. And like I said earlier, the red flags, sometimes we get lucky and they just show up, but a lot of times we kind of have to make our own luck and we have to find the red flags instead of just waiting for them to appear. So asking the right questions during the recorded interviews, letting the conversation flow and letting the conversation lead the follow-up questions, obtaining an ISO report, conducting initial surveillance if there's any indication that they might be lying, or even simply as a matter of practice, doing initial surveillance just to see what their movement looks like, how they move, how they act, what they do, what their activities are, and social media. All of those things, doing that initially will give us a baseline, right? That's the foundation. Is there anything on there that's inconsistent with what the information that they're giving us, right? Then we go to the next level, which are medical records, SMOs, and IMEs. Medical records are incredibly useful in establishing a fraud claim, not only because the claimant is more often than not asked whether or not they have any prior history to that same body part, but also because a lot of times they'll refer, depending on the medical records, right, they'll refer to prior accidents that perhaps the claimant denied ever occurring. Like I mentioned earlier, this was a one-page MRI report, and in one line had compared to MVA MRI from X, right? That one line was what told us that there was an intervening accident and something that we could hang our head on, not only A, for fraud, but B, to defeat any future payment of benefits, and C, like we'll talk about later, assisting in a favorable settlement. So really knowing your case and looking at those medical records is important, because there is information there that, again, builds on that initial foundation, right? If we see on social media that they belong to a recreational basketball league or flag football league, and they have games every Sunday, and then the medical records, they're saying, well, I have trouble standing up, I can barely walk, I can't run. Well, the question is, they're not saying that they can't play flag football, right? But it's assumed that if you're saying you can't run,
They may sit on the bench.
right? And so building on those things, SMOs are incredibly useful tools. That's your physician, that's the employer's physician. And we can ask them to make sure that they verify certain things, make sure that there hasn't been an intervening accident, make sure that what they're telling their treating physician in terms of what their activity level is consistent with, what the reality is. Now, without getting too deep into the weeds, you do need to be careful with certain things with regards to SMO and what you disclose to them, because something that might not be discoverable at the time of the SMO may become discoverable if you provide it to the SMO, specifically, surveillance recordings or something like that. If you give it to the SMO for them to look at, that may be something that, if you're in litigation, might not be discoverable at that particular moment, that you then have to provide to opposing counsel, right? So,
Well, if it's gonna be in their report, you may have to provide that, which generally after their deposition, you would have to provide that anyway.
right. So it's just important, again, without getting too much into the weeds, just be mindful of what's disclosed to the SMO. But there's nothing stopping you from saying, confirm that there have been no intervening accidents, confirm that there's been no auto accidents, confirm that they in fact have trouble walking, have trouble, can't really run or anything like that. IME's same sort of scenario. The IME is going to ask certain questions, and if they're denying these things, well, then again, that builds upon your fraud. You have this consistent behavior of misrepresentations that sort of build on top of each other. If we're in litigation, then we have even more tools available at our disposal. Subpoenas are fantastic tools to uncover things. Medical canvases, if they're saying, I've never had any injuries to my back, you use it depending on the situation and depending on the case. If you have an 18-year-old employee who works in an office and tripped over a cord and landed wrong, well, that might be something that you might think twice about a medical canvas versus, a 45-year-old employee that works construction, because one is far more likely to have prior treatment than the other. And so you want to make sure that you use those litigation tools appropriately, but having subpoenas, being able to get medical records that are not related to the accident
Pharmacy.
is incredibly useful. Pharmacies, for example, they'll have a list. Okay, and if you see this person, a year before the accident had a prescription for Norco or gabapentin or any one of those pills that there's generally given as a painkiller or a muscle relaxer. Well, now we have, okay, well, do we need to get the records from this doctor? That's having the subpoenas is an amazing tool. And then of course, discovery and discovery motions. Getting all of the evidence, particularly with regards to social media, is great. But if we're not in a position to be able to introduce them at trial, well, that becomes a little bit more complicated. So being able to use the discovery motions to further that, requests for admission that are very targeted and very specific, giving them an opportunity to kind of dig themselves a deeper hole. All of those things, like I said, you just build upon each other, right? You start weaving this web and tying, connecting the dots, I think is a better way to put it, to paint this picture of saying, well, this isn't just a one-off lie, right? This is somebody that's exhibited a pattern of not wanting to disclose X, Y, or Z, but still trying to push for benefits. And I'll add one thing to the initial investigations is always the 1025 EE and the Form 1020. The Form 1020, there's this belief that you can only send that if they've been released to return to work, and that's simply not the case. You just want every month to get them. And there's two benefits for that. Number one, if they're lying on the Form 1020, then that again builds on that foundation of fraud. And number two, it ensures that they are, whether or not they're working, and if they are not compliant with that, it gives you an opportunity to suspend benefits, right? Because once you give them that form, if they don't return it to you within a particular time
30
frame,
days.
then you at that point can suspend benefits. Now, those become payable once again, right? Once they send you the form, but it still kind of helps you put the things together to make sure. And the 1025E is incredibly important because we have seen a lot of times the argument that said where the claimant will say, oh, I can't do my job, but I'm going to, work for cash or get a remote job where they're just sitting at home earning income. And once we kind of start working towards that fraud, it'll be well, I didn't know I couldn't work and get this benefit. I just thought I couldn't do my job that I was doing before, And so it goes back to, again, all of these things work together. It goes back to what Megan was saying about other factors to consider. If this is a person that has had very entry-level jobs with a 7th grade education that may have actually believed that versus somebody that, has X amount of experiences in a supervisory role, has either a formal or undergraduate graduate school certificates, to what degree
Very.
did they understand? And so I think the most important thing to take away from this particular slide is that everything works together. It's not just one thing standing on its own, which, to be fair, there are certain instances where that may be the case, but 95%, I would argue 95% of the time, it's things that you're going to connect the dots to paint this picture that you want to paint.
Really quickly.
What?
Go ahead. Okay, really quickly, just a few tips to highlight some of the points that Andres made. The ISO report, almost all insurance companies are going to have access to an index report or an ISO report of some kind. There's apparently, we talked to an adjuster recently who said there is a form. There is an ISO, like a claim request form that you could fill out and submit to insurance companies to get additional information on those claims. That's not saying that they are going to respond or going to provide it to you, but that is a helpful tool to further your investigation prior to litigation. Because whenever the claim's in litigation, we can just subpoena those records and get those records for those prior accidents. But if you're not in litigation, that may be the only way that you can get it. Also, with respect to social media, don't just check the TikToks, the Facebooks, the Instagrams, things like that. Other helpful sites to check. Andres actually taught us this. Check their Venmo. Right? Are there transactions that are being exchanged back and forth? Are they being paid for any types of services? Look at Etsy. Do they have some type of craft project that they've started since they've been home and out of work? And are they selling things online? Facebook Marketplace, anything that you think that they could be posting publicly about their daily activities or income that they could have earned could be helpful in establishing your fraud claim. Also, second medical opinions. We cannot stress the importance of getting our experts involved at the very onset of the claim, because that could lead to either discovering the fraud claim super early or sort of getting ahead of things, because the claimant is immediately going to go to a physician. They're going to report certain things. We're already a step behind at that point. So if we get our expert involved early, then that kind of puts us on an even playing field. That way, when we go to court or whenever we get an IME, there is no argument that, well, their physician knows them better and they've been treating them for 6 months, and our physician only saw them for one time and only looked at certain medical records. So you want to start getting an authorization at the onset of the claim, gathering those medical records and submitting all of those to our second medical opinion physician early on in the claim. And if you need help finding a physician in a particular field in a particular region in Louisiana, that's where we can come in. We do that. We do it all the time. We set up those opinions, those appointments, and we draft the questions that are sent to those physicians. And again, we don't disclose those questions or the contents of our letters to the other side. So that's our strategy, right? That's our communications with our expert in anticipation of litigation. So those are definitely things that you want to be mindful of. Also, with regard to discovery motions, we file a lot of these motions to preserve social media evidence. If there is something on their social media that has become a red flag, or you see, like Andres said, if they delete their social media or they make it private, we can file a motion with the court and get an order that prevents them from doing that under the threat of spoliation or destruction of evidence.
And I'll just breeze through these next couple of slides simply because I want to make sure that we have enough time to address 1208.1. But, in this slide, which again, we can provide, at any point, just reach out, there is sort of a listing of warning signs for workers' comp fraud, which I think we've kind of tackled some of these, but again, it's just making sure that you're going through it. If you see something that doesn't make sense, make a mental note of it, make a note on your actual notes or journal entries. Make sure that you're looking at it. There's certain things that'll stand out. There were no witnesses to the accident. It's a brand new employee. The details around the accident changed. The injury was never reported. Things like that. should automatically be raising flag.
My favorite one is that the claimant's hard to reach. If you have a claimant who is TTD, right? So if they are temporarily totally disabled, they're saying they can't work, they've been off of work by a physician, you call them several times, you email them, and you can't get in touch with them, what else are they doing? Right? They're sitting at home all day. They should be able to pick up the phone and answer it.
Correct. And again, we touched on these earlier. This is the 1025 EE and the 1020 forms. If you're not sending them with your initial grouping of letters that you send that include usually the choice of physician form, so some sort of explanation of benefits, etc., you want to make sure that you send these as well and make sure that it's received too.
If you don't send the 1025 EE, the one that's on the left, it's going to be very difficult. That's a certificate of compliance, very difficult to establish a fraud claim at that point. You have to make sure it speaks to the intent element, that they are aware of the consequences, that they are aware that it's unlawful to make a false statement or misrepresentation, and that the consequences of doing so. And that's set forth in that form.
And with regards to forms, again, real quick, I'll just say this. If you have somebody that's had multiple workers' comp claims in the past, be extra mindful when you check their forms, especially the choice of physician form, because the choice of physician form, if you know, it has two lines. The one is I select, Dr. So-and-so as my choice of physician, or another line that says I choose my employer's doctor as my choice of physician, Dr. So-and-so. I've seen a lot more coming through nowadays, the choice of physician form where the employee, and this, I've noticed it particularly with claimants that have prior claims, what they'll do is they'll put the doctor's name under I accept my employer's choice of physician. Because if they've had claims in the past before, especially if there's been an attorney involved, they know that we can then send them to our doctor, right? But if they accept the employer's choice of physician, if the employer directs them to a doctor and they accept them as that doctor, that now causes an issue with us being able to get a second medical opinion, right? Because that doctor is both of our doctors. And so be extra cautious when reviewing those letters. Make sure that they're filling out the correct section, especially again with A, employees that are represented immediately at the onset of the claim, and B, people that have had existing claims. Or prior claims, I should say. So now you've done all of this work to be able to put forth the best case to establish fraud. What are the consequences of it, right? Number one, of course, is the forfeiture of workers' comp benefits. Number two is civil penalties, and number three is criminal sanctions. Going back, if you look at the form 1025 EE, that'll list what the potential criminal sanctions are for certain things, right? It generally involves the how much what the dollar value is of the benefits that they obtained through their fraudulent actions that will determine the potential consequences, which include a fine and potentially imprisonment.
Also, what's not on here is restitution. So anything that you have paid up until that point, there's a chance that you could reclaim that amount.
Right, which that falls under civil penalties. And also collection, asking for court costs, attorney fees, expert costs, things like that you can ask that would fall under civil penalties that you could potentially ask. Realistically, whether or not that a judge will order that will depend on the facts of the case. The judge, it's very fact intensive and venue intensive, but those are all penalties that can be assessed. And I'll leave you with this before I end on 1208 fraud. Is if you have any older claims, the PPP loans, the who received them and the dollar amount is public information. That's a quick Google search will tell you. If you have any claims that are 2020 or older, or possibly even 2021, see if you can find them in that PPP loan archive, because I have found on 3 different occasions claimants that have said that they are unable to work, but I find them on the PPP loan saying that they own a business with, 3 employees and received X amount. So not only are they lying about their ability to work, they're lying about their income and wages that they've received. And so again, doing things like that, conducting those little investigations that don't necessarily take a lot of time, but can yield significant results is all part of the one thing together.
The same, kind of on the same note, unemployment benefits, right? They can't collect unemployment and also be collecting workers' comp. And then prior workers' comp claims, you can file a request with the unemployment office, or you can file a request with the Office of Workers' Compensation and get those types of records. So if you have questions about how to do that or where to file the forms, be sure to let us know and we can help you with that. Okay, so with the few minutes that we have left, 1208.1 fraud. Okay, so this involves a misrepresentation of on a post-hire medical questionnaire. So really 3 things that you're going to need to have. You have to have a pre-existing condition, a valid post-hire medical questionnaire that meets the requirements of the 1208.1 statute, and also a failure to answer truthfully after the sufficient notice. So let's talk about the pre-existing condition. So there are 2 situations that are presented here. So one is they misrepresent or they lie about a condition that is the same medical condition that is the basis for their workers' compensation claim. So they have a back injury, and on the form they check off they've never had any back injuries, they've never had any back surgeries. Okay, or they have a knee injury, and if they mark off they haven't had any knee surgeries or knee conditions or knee treatment. The second situation is a situation in which it is not the same body part, but it is a body part or a condition that would affect their employer's ability to collect from the second injury fund. So what the second injury fund is, if you paid medical benefits and indemnity benefits, if there is a pre-existing condition, they can potentially file, the employer can file for recovery with the second injury fund board, and they would be entitled to a certain percentage of that back, right? But there are several requirements that you have to have in order to establish a viable second injury fund claim. The most important of which is knowledge. You have to have knowledge of that pre-existing condition and chose to hire that the pre-existing permanent disability, really, and choose to hire or maintain that employee's employment regardless of that condition. This is a very, very fact-intensive question and detail-dependent question that we assist many employers with on the daily. An example of this type of condition that we've seen more frequently is diabetes. Okay, so you have a claimant with a shoulder injury. Okay, it is proven, it's scientific knowledge that a claimant with pre-existing diabetes is going to develop frozen shoulder, right? A lot of times there'll be a delay in treatment or a plateau in recovery following a shoulder surgery. And if you look back at the medical records, you'll see, look, they have diabetes. Okay, so that diabetes combined with the shoulder injury has made them worse than would it have been had they just had the shoulder injury. So a lot of times we recommend the employers file for second injury fund recovery based on that pre-existing diabetes. But again, they have to have knowledge. Where 1208.1 comes is if they don't disclose that, right? So had they disclosed that to you, we would have been able to recover under the second injury fund. And so that right there creates that prejudice that we're talking about, because there has to be, while with 1208, you're just looking at the intent and there doesn't have to be prejudice. 1208.1 does require prejudice. And so the way to do that is file for the second injury fund recovery, let them deny it, even if you don't think you'll get it, let them deny it, and then file your 1208.1 fraud and you have the requisite prejudice. To that end, the post-hire medical questionnaire has to be adequate, has to be valid. There's more and more push for it to be done on this exact form, but realistically, the statute only requires that there be a written form and that there be proper notice. The safest way to go about it is to use this form, because you see the warning right there in the middle of it that says failure to, can't read it from here, but that's the language, that's the magic language. Without that magic language, you do not have a viable claim for 1208.1 fraud. Must be prominently displayed, black face block lettering, no less than 10-point font. There are defense attorneys, I've never had to do it, but there are defense attorneys that will hire experts, graphic design experts, to examine and evaluate the style of the font, the typeface of the font, the size of it, everything, just to be able to establish a viable claim for 1208.1 fraud.
A quick example on that is a case where the form was printed and then copies just kept getting made, and then, you know, copies of copies and copies of copies and so on over the course of several years. And then, you know, in this particular case, the claimant signed it very quickly. That attorney hired, like Megan said, an expert to come in and say, because the form, and it was this exact form, right? It was the Louisiana Workers Commission form. Because it had been copied so many times, it no longer fell within the parameters of this, of what the requirements are, meaning it was no longer at least a 10-point type font. Yes. And so while some of these things may at first glance seem almost ridiculous, you know, getting an expert to come in and talk about the size of the font, it's best to err on the side of caution and just use the form, make sure the employers, as a way to help save them money and save them headaches later on, they're using ideally this particular form. If they have their own form, that it is within the parameters of what the statute and the case law contemplates.
Okay, so your consequences of 1208.1 fraud is basically just your forfeiture of workers' compensation benefits. There is no restitution option or civil or criminal penalties. Okay, so now that we've gone over really what fraud is under 1208 and 1208.1, how do you use it? So obviously it could be a defense to your claim, right? So that's the easiest way to defeat a claim, right, is to show, well, they misrepresented this, they forfeited benefits, we don't have to pay anything. But there are so many other ways that fraud could be used to your advantage from a strategic perspective that don't really involve the defense of the claim. So under, I believe it's 1313, the only way that an employer or insurer, a defendant in a workers' compensation claim, can file a 1008, a disputed claim for compensation, is if it's fraud. Yeah. It's fraud.
It's either fraud or to appeal the medical director's decision.
Yes. Okay. But so if you don't have one of those, you're going to be faced with an exception of no right, no cause of action, saying that we don't have the ability to file suit. The way to do that is to allege fraud. So a way around that. So you gather the information that you can. You only have to allege enough facts to bypass that exception, and then you're in court. Right. And once you're in court, you have all the discovery tools at your advantage, right? So you have your subpoenas, you have your interrogatories, your request for production, your request for admission. You can do all of those things. And once you have that, that becomes the tool to either A, get more information in order to defend the claim, or to B, gather more information to establish fraud.
Yeah, something important to consider with that is whenever we file fraud, we need to plead it. We're pleading fraud with enough specificity to where they can mount a defense. It's no different than when the claimant's attorney files a 1008. For us to not consider filing an exception of vagueness, they need to be able to show with enough specificity what exactly they're arguing. And so this is a very, very good tool and a very, very good way of being able to get into court and be able to conduct discovery, issue subpoenas, ask the court for an IME, etc. But it's important to know that you need to have at least a little bit so that you can go into court. Like Megan said, you need to be able to have just enough to defeat that exception. So it can't be in a case where there's absolutely nothing. You can't turn around and say, okay, I'm gonna file fraud on this.
That's frivolous if you don't have some basis for doing
Yes,
so.
not only is it frivolous, but I can think of several claimants attorneys that if they uncover it, they'll turn around and say, well, this is fraud on behalf of the employer, right? Because what they're trying to do is they're trying to kind of, this is what they'll say, right? They're making things up so they can get into court and do all these other things. And so all you need is an inkling, just enough to defeat it. And then with that, that allows, like Megan said, to go into court and be able to do all the things that we need to do with regards to building on that.
So you mentioned the IME, right? So an IME is an independent medical examination. We use those whenever there is a dispute as between the treating physician and our second medical opinion physician. There are two types of IMEs. You have your state IME that can address condition and work status and the necessity for future medical treatment. And then you have a court-appointed IME that can address issues, technically issues as to causation. The only way to get a court-appointed IME is to file a 1008 with the court and ask them to do so. Generally, there are lots of attorneys that will allow us to file for a court-appointed IME, but this is easily defeated by an exception of no cause, no right of action, like I've said before. So a way to get that IME is to file for 1208 fraud or 1208.1 fraud, and then kind of get it that way. As you know, fraud is a good way to kind of move towards settlement. But it's important not to overuse this, that you'll want to make sure that you have legitimate fraud. A lot of attorneys, if you just say, oh, I'm going to file 1208 fraud, there's a lot of claimants attorneys that like to do that to us. Well, I'm going to file fraud against the employer. Unless they have a legitimate basis and they can show me some facts, I'm not really going to budge on that. And I think a lot of them are the same way. So make sure you have a reasonable basis for your fraud.
Yes, because it really can help drive the value of the case down and lead to a favorable settlement. But also consider that you don't want to lay all your cards out on the table during settlement, right? Because that gives them an opportunity to develop a strategy to kind of try to defeat that. And so with that said,
we'll answer any questions that you'll have.
Yeah, so feel free, just let us know if you have any questions.
Oh, our contact information is on the last slide too.
Yes, our contact information is right here. And do you have any questions for us? Excuse me, right now, or anything you'd like us to address?
Okay.
I have a weird question though. I'd like to know, like, does the court kind of lean towards the injured worker, the claimant, or the insured and the carrier in fraud claims? Or are they quite fair?
I think both of us will have similar but different answers. So I think the first thing is, like all the questions that seemingly attorneys answer, it depends. Yes. So number one is the venue. Certain venues are have different tendencies, right? So we know that certain venues are going to be more likely to look at all the evidence and essentially try to find a way to rule in favor of the employee. And then there are other venues that are going to look at the evidence objectively and then just rule on that basis, right? And so I think number one, it depends on the venue. Number two, even within the venues, I would say it depends on the judge. There are certain venues that have more than one judge, and each judge, while they are pretty consistent, they're going to have slightly different tendencies or will be more open to certain arguments. And then number three, of course, it depends on the facts, right? I'll give you an example of a recent case where fraud was essentially denied, even though there was footage where there was even some confusion about whether or not the accident even happened. And because of that particular venue, fraud didn't go our way. But had that been in a handful of other venues, it would have almost definitely happened. So it depends.
Does that answer your question?
It does, thank you. It sure does. So it's just the same listing that we went over yesterday, so it would apply to all those areas in Louisiana? So it's not just to the claims itself, but to fraud claims as well?
Yes,
Yes.
Okay.
Yes, because our fraud claim would either be followed as its own 1208 in the particular district, or it would be alleged as a defense to those claims, but either way, it'd be filed in those districts that you saw on the map yesterday.
and
Okay.
I'm sure they describe what the different districts sort of have as their tendencies. That's gonna be consistent throughout, right? Whether it is something like a fraud argument, whether it is us filing a, a 1008 for an IME. There's some courts that regardless of whether, like if we file a 1008 requesting an IME, they'll hear it and they'll generally appoint an IME unless opposing counsel brings up that exception of no cause, no right. Whereas there are other venues where the court themselves, I've had this at least on 2 different occasions with 2 different judges, the court itself will say, no, I'm not hearing this because this is not a 1008 for an IME. It's not something that's allowed on the statute. And so those
Which they shouldn't
tendencies,
do on their own motion, but that's a
Right.
topic for another day.
yeah, those tendencies kind of will apply across the board.
Anything else for us?
Thank you. Do you mind if I ask one more question before you go? Just all the way to the
Right.
beginning, you mentioned that if, like in a case where someone would want to add additional body parts later on in the claim, you were recommending an SMO. Is that the best way to address that?
Yes, that's definitely what I would recommend.
Yeah, so this happens a lot, especially when attorneys become involved. Something will happen at work. They'll say, oh, my back hurts, right? Then 2 weeks later, they'll come back and say, well, my back and my neck hurts. And then 2 weeks after that, they'll come back and say, my back hurts, my neck hurts, but now I'm also getting like shooting pains down my legs. And so they are adding those. My recommendation is on nearly every case, but especially TBI cases, is get the SMO involved in early, right? That way the SMO can look at it and say whether or not these additional complaints are realistically A, can be supported by objective findings, and B, would be consistent, right? A lot of times you'll see the SMO look at it and say, yes, there were back complaints initially, and then in the course of weeks, ridiculous complaints, that shooting pain down your legs develop. You'll see SMO say that is consistent with this particular kind of injury, right? It's something that develops later on. But other times, if it's something where you injured your neck and now you're adding your knee, that should immediately bring up a red flag, because it's like, well, those are they're so far apart and so different that automatically it's where's this coming from type of thing. So yes, absolutely, the SMO, getting them involved is important.
So I will, along those lines though, for the SMO for the additional body parts, right? So claimant is entitled to their initial choice of physician in any field or specialty, right? If their treating physician says that they need to be referred to a different specialist for a particular body part, even if you are denying that body part, there are courts that have held that you could be subject to a penalty and potentially attorney's fees for failing to authorize that initial evaluation with that physician. So, again, it's fact intensive, but what we would generally say to do upon reviewing the facts of the case is say, approve that initial evaluation, don't approve anything else after that until we get the SMO. So find out when the initial appointment is with that physician, have them go to schedule an SMO, provide that visit summary from the treating physician to that SMO, and let them make a determination at that point. Because then from there you go to an IME and you can kind of work in defeating the claim at that point. But I wouldn't just authorize it and go from there or file fraud. Another thing that I don't think we mentioned is if you're filing fraud, don't terminate benefits, right? like, once you have an initial investigation of fraud and you think you have something, continue to gather that information. We can file 1208 fraud and you don't have to terminate benefits when we do that. You can keep the benefits in place, then we can file fraud. And then if there's a successful claim, then you can terminate and we're entitled to restitution for that or their forfeiture of that, right? But you're not subject to penalties and attorney's fees. And claimants counsels hate when we do that because they have to do all this work in defending the fraud claim, but they're not going to be entitled to any attorney's fees for that.
Yeah. And so yeah, that is definitely something to consider.
Any other questions?
Feel free to ask.
We have time.
Yeah, I just put a question in there that you were speaking about terminating benefits. So if we did that in the middle of a fraud claim, then we could be subject to penalties. Is that correct?
Potentially, yes. So the thing about suspending benefits, or well, first of all, you always want to put it as suspending benefits, right? Just avoid terminating quote unquote benefits, just suspend them.
But the court, when looking at P&A, even if you just say you're suspending benefits, like you want to phrase it that way, but they're going to still view that as a discontinuance, which could potentially subject you to an $8,000 penalty and attorney's fees.
If so, the way you want to look at it is, if you suspend benefits, were you reasonable in doing that, right? So in theory, if you have a very compelling fraud case and you decide to suspend benefits because of that, and then we go to trial and we lose, theoretically, as long as you were reasonable in your action, meaning that after an investigation, it looked very compelling that there was in fact fraud going on, theoretically, and I say theoretically because it's very theoretic, you shouldn't automatically be assessed penalties and attorney's fees, right?
But there are lots of courts that will automatically assess it. If you have fraud, you lose. Even if you were reasonable in doing so, you lost your claim. So they're going to award P&A.
Right. And so even if you weren't, and you'll hear this phrase a lot, arbitrary and capricious, right? Even if you weren't arbitrary and capricious, you had a pretty reasonable fraud claim. So that was the basis for the suspension. And you lose, then you might be subject to penalties and attorney's fees. However, there are instances where, and that's why we say it's very, very case specific, is because there are certain instances where the fraud is incredibly compelling and we say, you know what, we're just not going to be paying benefits, because, while the court might order restitution, depending on how much money or what we're looking at in terms of expense, what's the likelihood that we're going to actually get it back? And B, does this bring us closer to settling the case, right? And so we're going to make that decision on a case by case basis, but it's absolutely a situation where if you suspend the benefits and are unsuccessful in proving the fraud claim, that more likely than not, there is going to be some P&A exposure there.
A lot of employers and adjusters, the minute you even suggest that there's exposure for P&A, which there is, anytime that you discontinue benefits in any way, there's the risk of that, they sort of scare away from it. And so the way that we sort of avoid that is say, look, you can continue paying. We'll file the fraud, continue paying, and then we can see how the court rules and then come out that way. And that's the only way of definitively avoiding P&A in that instance.
Thank you both. That explained it well. I have no more questions. But I did enjoy listening in and just learning from both of you. So thank you both so much.
Oh, we appreciate it. And listen, if at any point you run into any case or anything like that where you have a question or you're looking through it and you see something that, you know what, this might look like it might be something, give us a call or shoot us an email. The screen right there, that's Megan's direct number and her cell phone and her email as well as mine. So anytime you have any questions, feel free to call any one of us, right? Megan, myself, Patrick, Mike,
Yeah.
Keith, Corey, any one of us can answer a
To
question.
be up until midnight answering questions. So.
Yes. So it's not a problem because we know that sometimes you look, one particular case, you find something, you're like, all right, this is gonna be good for my case. And you might be able to find the exact same thing on another case, but because the facts are gonna be different, it might not be as effective in one as the other. And so anytime you have a question, feel free to reach
But
out.
also venue. You mentioned the different districts. If you have a question about a particular judge or a particular court, or even the appellate court, so that's something to be aware of too. We may have a very favorable venue, like we perceive District 4, which is here locally in Lafayette, those judges to be, sort of middle of the road, more conservative than some of the other judges. But it sits within the Third Circuit, which is the most employee-friendly appellate court in the state. So if you have any questions about those things, we'd be happy to address those as well.
All right, thank you both.
So
You're welcome. Have a good one.